Hello and welcome to today's webinar. My name is Stacey Sinclair and we are delighted to be back here with you again today. Thank you very much for joining and returning if you are a regular to our webinar series. So today, of course, we have an adjudication update. This is the fifth in our webinar series. And to take us through the last 6 months or so of the latest and greatest cases, we have two specialists in adjudication here with us today. First, we have James Mullen, Fenwick Elliott Senior Associate, and Four Pump Court Barrister Daniel Churcher. Both specialize in construction, engineering, and energy law, and both practice all forms of dispute resolution, including, of course, adjudication. And in addition, Daniel is the editor of the Adjudication Society newsletter. Welcome, Daniel. Thank you very much for joining us. So just a few admin points as usual. Everyone is on mute. And we encourage you to ask questions as we go. Hopefully you've now seen the questions toolbar on the right-hand side of your screen, and please feel free to fire away. And rest assured, common question typed into the questions box. A recording of this webinar and a copy of the slides will be available on our website in due course after this session. So thank you very much again for joining. And I think with that, James and Daniel, I shall hand over to you.
Thank you very much, Stacey. Thank you everyone for coming today to listen to us. And thank you to Fenwick Elliott for inviting me along. As Stacey said, I think the last adjudication update that Fenwick Elliott did was about 6 months ago, in March 2021. So we have a limited period of time to draw on to find the cases. And I think because of that, and also to avoid boring you by just running through case after case, what we're going to do is James and I have each picked a topic which we think is at the frontier of the law of adjudication at the moment. And we're going to talk about those issues a little bit discursively. I'm going to talk about payment disputes, and James is going to talk about insolvency post-Bresco. And then we're going to run through, at the end of the talk, some of the more recent cases, I suspect, at quite a rapid clip. And we'll try and leave some time, decent time, for questions at the end. So, see if the slides work. There we go. Maybe. Magic. There's the agenda. And payment disputes. So why am I talking to you about payment disputes? You've heard it all before. I think everyone knows at least a little bit about where the law has got to in relation to payment disputes. So why am I bothering you with it today? Well, the first reason is that it doesn't feel like an adjudication talk unless you've heard the word smash and grab at least 10 times. So there's that. I think also, certainly in my practice, most of the adjudications that come across my desk are payment disputes. And I think the reason for that is that it is an area of law where parties are incentivized to really dig around in the corners and test the limits of the law, test the limits of the statute, and test the limits of the decisions that the court has already reached. And as a result, what often happens, and I'm sure lots of those listening will have been in this situation, is an employer has been the subject of a smash and grab adjudication. They're going to have to pay out a load of money that they don't particularly want to pay out. And they go to their lawyers and they say, number one, are there any weird and wonderful arguments I can come up with as to why I shouldn't have to pay this money in the first place? And number two, what can I do to get the money back if it subsequently turns out that I have overpaid? And so what the lawyers then do is come up with the weird and wonderful arguments. They go to the TCC on enforcement. And as a result, we've had a pretty constant stream of developments in the law relating to payment disputes over the last 7 or 8 years now. So what I want to do is very quickly recap how we got to where we are today. And then I want to set out what I think is the current frontier in payment disputes and what issues I think are likely to appear in the reported cases over the next year or two. So stage number one of the recap, ISG and Seavich. Now, this was the beginning of the golden age of smash and grab, because what the court said is if you haven't put your notices in, not only have you got to pay the notified sum, but at least for that payment cycle, you have no right to go back and demand a revaluation of the work. And I think what the court concluded was that if you don't put your notice in, you have effectively agreed the valuation of the account at that stage. As I say, golden age of smash and grab, but sort of makes sense in the context of interim applications, because of course what the court had in mind was it may well be that you overpay on payment cycle 10, but that doesn't really matter because you can correct it later in payment cycle 11, 12, or whatever it might be. So the employer is going to be out of the money for a month or two, but there is going to be an opportunity, the court has in mind, there is going to be an opportunity to fix it down the line. Second stage, Harding and Pace. This was a case in a final account context. And what the court said was, in the final account context, where you don't have that opportunity to correct it at a subsequent payment cycle, because clues in the name, it's final account, there isn't any further accounting process. What the adjudicator needs to decide is the sum properly due. And that, the court said, is distinct from the sum that might have been applied for, or the sum that has become the notified sum by reason of the payment provisions in the 1996 Act. And again, looking at it from a sort of policy angle, you can see why the court reached that decision. As I say, court wants to make sure that the door has not been closed on the employer coming back later and saying, yes, we accept we had to pay them £1 million back then, but now that we've dug around in their account and we've done a bit of analysis on their loss and expense and we've looked at some of their variations, we can see that actually we shouldn't have paid them a penny and we'd quite like our £1 million back, please. Now, the one thing about Harding and Pace is a slightly unsatisfactory decision, firstly because it is principally dealing with the final account scenario, but also because it turned in part at least on the specific words of the JCT form that was involved in that case. And that was where those words properly due came from. And so a bit of doubt about the extent to which that case set down a general principle. And then stage 3, Grove and S&T. So Rupert Jackson comes to the rescue of employers everywhere. And what he says is, in the context of an interim application, you can adjudicate the true value, but only after you've paid your notified sum. So that's the recap. That's where we've got to, more or less. And what's really going on here? Topical picture from Squid Game there of people trying to pull each other into the abyss, which is often what adjudications feel like. And what's going on, I think, is there are two fundamental tensions at play. The first one is the commercial tension between the contractor who wants to be paid, and they're probably not particularly worried about whether they're paid the right amount or not. They just need to get some cash through the door so that they can keep paying their supply chain, so that they can keep paying their labourers, and they can keep working. The employer doesn't want to pay because employers never want to pay. And so there's that commercial tension. And then the second layer of tension is between two policy objectives that the court has in mind. The first one is that the court wants to enforce the cash flow policy that sits behind the 1996 Act, right? TCC judges have spent most of their careers in practice looking at what happens on building sites, and then once they get to the bench, they spend even more time hearing about what's happened on building sites, and they know very well how important it is for a contractor to keep the money coming in through the door. And as a result of that, there is, I think, a broad recognition that the policy of the 1996 Act to keep the money flowing needs to be given some force. Now, against that, the court has an inherent reluctance to ever be in a situation where it looks like the shutters have come down on any potential arguments about repayment, right? And any of you who have been involved in disputes which involve conclusivity provisions in contracts, i.e. where it said, if you don't challenge this final account for or within, say, 28 days, it becomes conclusive. You will know from looking at the case law that the court often will bend over backwards to avoid that scenario, because I think, like all of us, and judges in particular, they don't like the idea that there might be some sort of technical reason why money has to be paid over, but then you're shut off from digging around in the weeds and finding out what the real entitlement is. So again, another tension there between the two policies that the court wants to give effect to. And so what you end up with, and I think what you see or saw in the three recap cases I just addressed, is this tug of war between these different considerations. And what the court is trying to do is strike a balancing act between the two so that you end up with something that looks like a fair system. And of course, it might be thought that when you have something like the 1996 Act with these extensive, nicely codified provisions about what payments ought to be made, who has to pay what notices they have to put in, you might think that would be a nice, clear regime created by the statute. Of course, we all know that in practice it is anything but that simple. And so the way in which payment disputes have developed in reality is that there is a significant body of judge-made law which is not really rooted in the Act. And it's because of that, it's because the judges are basically having to fill in the gaps in this codified payment regime that you get this stark tug of war, as I've described, between the different interests and the different policy objectives. So where's the front line now? Well, what Sir Rupert Jackson said in Grove was both the Act and the contract must be construed as prohibiting the employer from embarking upon an adjudication to obtain a revaluation of the work before he's complied with his immediate payment obligation. So what he's saying there, can't even start your true value adjudication to get the money back until you've paid over the money in the first place. And you can see the policy reasons behind that, because otherwise employers are incentivized, as they often do regardless, to dig their heels in and just not pay until the absolute last possible moment. And of course, that runs contrary to the cash flow policy that sits behind the Act and also sits behind the jurisprudence in this area. However, what Sir Rupert Jackson said in Grove has not stopped employers from trying. And of course, there are plenty of ingenious lawyers at Fenwick, Elliott and elsewhere who are very happy to assist them in those efforts. So where have we got to? Hang on, there we go. Two recent cases which don't necessarily shed much light on the situation. The first one from a couple of years ago, Davenport and Greer. And this was a case before Mr. Justice Stuart Smith. He's now gone up to the Court of Appeal. And what he said is it should now be taken as established that an employer who is subject to an immediate obligation to discharge the order of an adjudicator based upon the failure of the employer to serve a payment notice or a pay less notice, i.e. they've lost a smash and grab, must discharge that immediate obligation before he will be entitled to rely upon a subsequent decision in a true value adjudication. And then later in the decision, he goes on to say the employer must make payment before it can commence a true value adjudication. That doesn't mean the court will always restrain the commencement or progress of a true value adjudication. And bear in mind that point about restraint. We're going to come back to that. But in any event, something of a conflict between those two passages. One says you can't rely until you've paid your smash and grab. The other says you can't even start your true value dispute until you've paid your smash and grab. And then a second decision, which was Mr. Justice Fraser in Broseley and Prime Asset Management. Now, this is probably obiter, but he was much less ambiguous than Mr. Justice Stuart Smith. What he said is attacking the validity of the first decision, a smash and grab decision, would be a remarkable intrusion into the principle established in S&T. It would permit the adjudication system to trump the prompt payment regime. So what he says is, again, you cannot even start your true value decision until you've paid the smash and grab. Now, why does this matter? The reason it matters is because of these sorts of timelines, right? If you are an employer and you've been the subject of a smash and grab adjudication, you go and take some advice and you are told, look, there's not really much way out of this. We might come up with some slightly shaky jurisdictional arguments to deploy at the enforcement hearing, but realistically, you are going to have to pay this money over, whether or not you think your contractor has in fact earned it. And unsurprisingly, employers tend not to like to hear that, because what it means is that they're going to be out of the money. And the question is how long they're going to be out of the money. So in scenario one, in the world of Mr. Justice Fraser, you can't even commence your true value until after you've paid your smash and grab. So you can see there that you might have, say, a final date for payment in month one. You don't get around to the smash and grab until, say, month 3. You get the award in month 4. You don't get around to enforcement in month 5, say. So that's the point at which the money is paid out. And then you go back to square one, and the employer has to start the whole process of adjudicating on true value and then getting that in front of the judge to enforce the decision. And of course, by the time you've got your experts lined up and your evidence lined up, it could be months or more before the employer gets a chance to recover their overpayment. Whereas if you follow the you can't rely approach from Mr. Justice Stuart Smith in Davenport, then you can see the second scenario, the second timeline on this slide, where the smash and grab decision comes out, the employer can get on with their true value while the contractor is going about enforcing. And then if you time it right, you ought to be able to get yourself into a situation where you can bring your true value enforcement application to the court not long after, or not too long after, you've paid out the money. And so employers are often very keen to do this. Let's get the true value adjudication up and running so that we will be in a position, once we pay out the smash and grab monies, to get that money back as quickly as possible before our contractor has any time to head off down to the casino or go bust or whatever else it is they might do, and we can try and get our money back in that way. I think at the moment it is ambiguous about what exactly an employer can do. And there's two sources of ambiguity. First is it rely, or is it that you can't even commence the adjudication? I think on that, on balance, if we look at what Sir Rupert Jackson said in Grove, and if we look at what Mr. Justice Fraser said in Broseley, it is probably right to say that you can't commence your true value, or perhaps right to say you can't commence your true value. But if that is right, well, what does that mean for the status of your second true value adjudication? Is it a point which goes to the jurisdiction of the adjudicator? Does it mean that the adjudicator in the true value has actually done nothing contractual at all because they simply do not have the power, to proceed until the smash and grab sum is paid? Well, that's quite problematic, I think, because, of course, there is a statutory right to adjudicate at any time, and that would seem to cut across that, and the parties have agreed that they can adjudicate at any time. But if it's not that, well, what happens? Does the adjudication sort of hang in abeyance until the money's paid over? Does it somehow snap into validity at some later date? Or, per what Mr. Justice Stuart Smith said in Davenport, do you need some sort of positive step by the contractor to restrain the second adjudication? And what we mean by that, of course, is running off to court and getting an injunction against the second adjudication. I think it has to be that latter option, i.e. the contractor has to take some active steps to stop the second true value adjudication, because otherwise it's just not entirely clear what the status of that second adjudication is. And it's also not entirely clear why the court would have the power to stop it going ahead. There we are. Those are my thoughts on payment disputes. I'll be back shortly to talk about some cases. I'll hand over to James now, with apologies for running over slightly on that first section.
Thanks, Dan. Right. Ooh. So I would like to look at the topic, or the case which was recently handed down by the Court of Appeal last week, so it's still reasonably hot off the press, of John Doyle Construction Limited, who in liquidation, against Erith Contractors Limited. Now, this is the first adjudication enforcement case since the Supreme Court decision in Bresco. The primary issue which the John Doyle case looked at was whether adequate security had been offered to contractors, but it also looked at the broader issue whether an insolvent company can enforce an adjudicator's decision. Now, just a very, very quick recap of Bresco. Bresco were in liquidation and they commenced adjudication proceedings against Lonsdale, claiming for unpaid work and damages for repudiatory breach. Lonsdale invited Bresco to discontinue the adjudication and invited the adjudicator to resign on the basis that Bresco was insolvent. The adjudicator refused to resign and issued a non-binding decision giving reasons. Lonsdale then commenced Part 8 proceedings seeking a declaration and an injunction preventing Bresco from continuing with the adjudication. Now, it was agreed that the adjudication would be stayed and that neither party or the adjudicator would take any steps until the Part 8 claim had been resolved. So the matter went all the way up through the TCC, the Court of Appeal, and to the Supreme Court. And the end decision was that Bresco had a contractual and statutory right to adjudicate, and it would ordinarily be inappropriate for a court to interfere with the exercise of those rights. Insolvency didn't mean that there was no longer a dispute or that claims fell away. And on this basis, the adjudicator in Bresco had jurisdiction to deal with the dispute which had been referred to him by Bresco. On that basis, the Bresco adjudication, which had been commenced 2 years earlier, was allowed to continue. Importantly, though, in the Bresco decision, the Supreme Court weren't asked to decide whether an adjudication decision would be enforceable by a insolvent company. This was purely primarily dealing with whether an adjudication has jurisdiction to deal with a dispute referred by an insolvent company. But in overture comments, Lord Briggs did suggest that summary judgment to enforce an adjudicated decision will frequently be unavailable when a claimant is in liquidation, either because the court will refuse to grant summary judgment or they grant it, but then they order a stay of execution. So turning back to John Doyle, in this instance, unlike Bresco, we actually went through the adjudication process and we got an adjudicated decision. So just a bit of background. The parties entered into a subcontract for works at the Olympic Park. This was based on the NEC3 form of contract and it provided for adjudication. There's quite a bit of sort of history to this. In 2012, before the works completed, John Doyle went into administration. Erith had to complete the works itself at a cost. And in 2013, John Doyle went into creditors' voluntary liquidation. The dispute then arose in relation to the final account. In 2016, John Doyle's claims were assigned to a third party called Henderson & Jones, who appear to be a company that specialises in purchasing claims from insolvent companies and running them themselves. In 2018, John Doyle commenced adjudication claiming for £4 million. Erith argued that John Doyle had already been overpaid by £3 million. The adjudication took 5 months, which the Court of Appeal noted in itself probably indicated that it wasn't suitable for adjudication. But in any event, the adjudicator awarded John Doyle £1.2 million. Another couple of years passed, and then John Doyle eventually sought to enforce the adjudicator's decision. Now, it's obviously an established principle that adjudication is binding pending final resolution by the court, i.e. a party that is not happy with the outcome of an adjudication has the option of rerunning that dispute through the court. Now, the issue, or the primary issue on John Doyle, was in relation to security, in relation if the decision was enforced and Erith were required to pay the 1.2 million. The concern was that 1.2 million would then be lost in the liquidation of John Doyle, and there would be little or nothing recovered if Erith decided to rerun the dispute and it was decided that the adjudicator was wrong and that Erith had been overpaid. There's also the issue that if Erith wanted to rerun the dispute through the courts, the issue of security for Erith's costs of those proceedings. The case went before Mr. Justice Fraser. in the first instance, and his judgment was handed down a couple of months after Bresco. In relation to the issue of security for repayment of the 1.2 million, Mr. Justice Fraser found that no undertakings or security had been offered by the liquidators. The security that had been offered in the form of a letter of credit or an after the event insurance policy had come from Henderson's. And then, having undertaken a detailed analysis of the security offered, Mr. Justice Fraser determined that it was inadequate. In relation to the security for the costs, again, security was offered in the form of an after the event insurance policy. There was also reference to a template deed of indemnity, which was said to deal with exclusions in the after the event policy, to which Erith objected. Again, having undertaken an analysis, Mr. Justice Fraser decided that the security offered by John Doyle was inadequate. On this basis, Mr. Justice Fraser refused to grant summary judgment to enforce the decision, but he did say that even if John Doyle had been entitled to summary judgment, he would have granted a stay of execution in any event. So the matter came to the Court of Appeal. There was 3 grounds for John Doyle's appeal, again, primarily dealing with the issue of security. In relation to security for the payment of the 1.2 million, the Court of Appeal, John Doyle argued that the judge should have found that not only had the liquidators offered security, but that security, which was a payment of the 1.2 million by Erith into an escrow account or a court, was in fact adequate. Now, this argument was not addressed by Mr. Justice Fraser in the first instance, because Erith said that this was not the basis that John Doyle had argued security in the TCC. On the other issue of security for costs, John Doyle argued that the judge was wrong, that inadequate security of costs had been provided on the basis of the deed of indemnity would only be engaged by commencement of proceedings by John Doyle and not Erith. And even if after the event and or the deed of indemnity did not itself constitute adequate security for costs, the judge had erred in law, deciding that Rule 6.42 of the insolvency rules did not provide adequate security for Erith. Now, Erith submitted that this last argument in relation to the insolvency rules was not put before Mr. Justice Fraser at first instance, and so it could not be raised on appeal. Now, before it decided the issues, the Court of Appeal made some initial observations, pointing out that the burden was on John Doyle to prove its case, and it noted that any undertakings offered for security must be clear, evidenced, and unequivocal. And the Court of Appeal said that John Doyle had failed to follow in these most simple steps. The court was fairly critical of the way John Doyle had approached the case. They said that their evidence was unnecessarily extensive. The court also said it would hardly be surprising if, out of this morass, it was not always precisely clear, either to Erith or the judge, what it was that John Doyle or Henderson's were actually offering and on what basis. And the court also noted many of these difficulties were the direct result of what I consider to be the unhelpful, aggressive approach to enforcement adopted by John Doyle's liquidators and Henderson's. To turn to the 3 grounds of appeal, the first ground of appeal was in relation to security for the 1.2 million. The suggestion by John Doyle that Erith should pay the 1.2 million into an escrow account or to the court had not been a clear and unequivocal offer by John Doyle. What was required was an undertaking by the liquidators to ring fence the 1.2 million, so it was not available for distribution within the liquidation. On this basis, the liquidators had given no such undertaking. But in any event, the liquidators couldn't have given such an undertaking because, or made an offer to accept payment of the 1.2 million into escrow or the court, because under the terms of their agreement with Henderson's, payment was to be made to Henderson's, not to the liquidators. And in any event, the Court of Appeal questioned whether payment into court was the proper way to provide security in respect of an adjudicated decision, as it goes against the principle of adjudication and the construction industry of maintaining cash flow, as it would deprive Erith, who are a working contractor, of cash while it was sat sitting uselessly within the court, and also wouldn't even be in John Doyle's and in the liquidator's hands of John Doyle. The ground 1 of appeal was dismissed. Ground 2 was also dismissed. It was acknowledged that the deed of indemnity only related to security for John Doyle's costs if it commenced a claim against Erith, and not the other way around. Now, obviously, usually it's the paying party that will commence court proceedings if it's not happy with the adjudicator's decision. So that wasn't particularly satisfactory. But John Doyle also said that an email from an insurer indicated that the deed did in fact include any claim which Erith may bring against John Doyle. Again, this was rejected by the Court of Appeal. Upon analysis, the deed of indemnity did not provide adequate security. And then on this basis, ground 2 of the appeal was dismissed. In relation to the last ground of appeal, again, this was in relation to security for costs. Under section 6.424A of the insolvency rules, it prioritises expenses incurred by a liquidator in legal proceedings over the costs and expenses in the liquidation. Now, firstly, the Court of Appeal held that John Doyle had not even raised this argument in the TCC, and so therefore is not open for it to now raise it on appeal. But again, upon analysis, it was irrelevant. So on that basis, the appeal was dismissed. So that was the first nail in John Doyle's coffin. The court then looked at the more broader issue of whether a company in liquidation is entitled to enter summary judgment on its claim arising out of a adjudicator's decision. Now, John Doyle's submissions on this were fairly limited according to the judgment. John Doyle argued that it was entitled to a summary judgment because the sum due was the net balance. There was no significant claims under other contracts, and there were no other non-contractual claims. And John Doyle said because these conditions had been met, there was, subject to the issue of security, an entitlement to summary judgment. And then when pressed further by the court, John Doyle also suggested that adjudication was pointless without summary enforcement. Now, the Court of Appeal held that even if the judge had erred regarding the inadequacy of the security offered by John Doyle still would not have been entitled to summary judgment. This was because John Doyle's arguments sought to rewrite Bresco. And in Bresco, the overture comments did not support the proposition that an insolvent claimant in adjudication enforcement should always be entitled to summary judgment. Also, the suggestion that John Doyle was entitled to summary judgment in the current circumstances was contrary to the principles established in Burgoyne. Also, the Court of Appeal said that it did not consider that the provisional finding of an adjudicator, even on a single account dispute, where no other significant non-contractual or other contractual claims arise, can be treated as if it were a final determination of the net balance in circumstances where the other party maintains its set-off and count and cross-claims. The Court of Appeal recognised that these findings may be unsatisfactory, but the Court of Appeal said that this assumed that summary judgment was the only weapon open to a claimant. The Court of Appeal gave two examples. They said that a claimant could commence court proceedings, or when the court proceedings rerun dispute, seek a larger sum, but then offer, presumably through a Part 36 offer or a quarterbank offer, to accept payment of the adjudicator's lower figure and thereby putting the defendant on cost risk. The court also suggested that it may be possible for a claimant to demonstrate entitlement to interim payment under CPR 25. So that was the second nail in John Doyle's coffin. The third and final nail was that the Court of Appeal said that even if John Doyle had been entitled to summary judgment, it would have granted a stay of execution. And this was entirely consistent with the authorities and with the way the court had sought to enforce judgments against claimants in a risky financial position. Again, Burgoyne, and obviously the case of William and Vargo. So the decision in John Doyle, it really does sort of limit the circumstances when an insolvent company will be able to enforce an adjudicated decision. It does seem very limited indeed, and it certainly would, I would have thought, bring into question the merits of insolvent companies or liquidators of insolvent companies commencing adjudication proceedings, knowing that there are so many hurdles at the end in order to enforce a successful decision in their favour. Okay, Dan, I think on to recent cases.
Great, thank you, James. As I said, I might rattle through these at a slight rate of knots, but we'll see how we get on. First case, come on slides. James, are you able to move the slides? I'm having issues.
No, I'm not actually.
There we go. Can I move them now? Right, I might ask James to be slide manager for the next 10 minutes. First case we want to talk about is Prater and John Sisk. Now, this arose out of a project to build a new aircraft maintenance hangar at London Gatwick. And from what we can tell, the parties have well and truly gone to war. This was an enforcement decision on the 4th adjudication. By the time it got to court, the court noted there was a 5th adjudication already on foot. And so, as I say, parties having a well and truly big falling out. Now, as often happens when you have these sorts of sequential adjudications, they build on each other, right? So when you have a favourable finding in adjudication 2, fairly obviously, you waive that favourable finding as much as you possibly can in adjudications 3 and 4. And in the usual way, subsequent adjudicators are usually bound by the main findings of earlier adjudicators. Now, what Sisk did here in relation to adjudication 4, they didn't say there was anything wrong with adjudication 4 in and of itself. Instead, what they said was, well, the adjudicator in decision 4 relied on findings in adjudication decision 2. And we have complaints to make about adjudication number 2. We say that was the decision in that adjudication was reached without jurisdiction. As a result, it's a total nullity. And as a result of that, any subsequent adjudication which builds on that shaky foundation is also on a shaky foundation and also a nullity, and you can't enforce it. James, have the next slide. Oh, I think I've got it. There we go. So first issue was, is it even open to Sisk in the context of a challenge to enforcement of adjudication 4 to collaterally challenge the decision in the earlier adjudication? Now, what Sisk had done is they'd served a notice of dissatisfaction with the second decision, and that was something that was provided for in their contracts. And they said that's all we need to do, because on a conventional analysis, if the adjudicator didn't have jurisdiction, then the whole thing was a nullity. All you've done is have a very expensive and no doubt interesting conversation with an adjudicator or someone purporting to call themselves an adjudicator, but we're not interested in it. The court, again, probably with policy considerations in mind, said, no, we're not quite sure about that. And we think actually what you've agreed is that the decision in adjudication 2 is binding unless and until it's overturned by the court. And if you wanted to avoid those findings in 2 being binding, then you should have tried to overturn the decision in court or arbitration. As I say, slightly surprising, and the basis on, well, the court doesn't say a huge amount about how they deal with that jurisdiction problem. And as I say, probably a decision driven more by policy than anything else, for the fairly obvious reason that you don't want parties in sequential adjudications, when something goes against them, going back over the past adjudications and finding something to whinge about, because then the whole sequence comes crashing down. James, could we go to the next one? If I can't do it. There we are. And then the court went on to consider, well, if they're wrong about that, was there an issue around jurisdiction in adjudication 2? And what had happened there was Prater had sought to refer some but not all of the elements to its final account. So they'd specifically referred to adjudication the dispute about the extension of time to which they were due, a dispute about the way in which provisional sums had been expended, and some contra charges claimed by CISC. And CISC said this is an absolutely classic example of multiple disputes, because each of these items is a freestanding dispute and you've asked for particular remedies in relation to each one. That's not allowed, and so adjudicator lacked jurisdiction. And what Prater said was, no, that's not quite right. What we've actually done here is we have picked little bits of a much larger dispute, which is our overall mega battle about how much we're owed on our final account. And the court agreed with that. The court said each issue was therefore linked to determining the real dispute between the parties, i.e. the final account. It would not be practicable for a party to be faced with either bringing all issues going to a complex account dispute in a single adjudication or bringing a whole series of different adjudications in relation to each and every issue arising. I think it's fair to say that one of the things the court probably had in mind in reaching that decision is that we all know, we go over to the next slide as well, we all know that one of the things contractors and employers really like to do in a final account scenario is ambush you at the last possible moment and say we're referring the whole final account to adjudication. Here are 6 expert reports and 5 witness statements, and it all runs to about 1,000 pages long. And good luck getting your response to all of that in 2 weeks or 3 weeks or whatever you can convince the adjudicator to allow you. And the court doesn't really, I think, want to be encouraging people to do that. So they say, yeah, that's fine, you can pick the best bits. Now, if you're in a final account dispute, this is a seriously useful tool to have, because of course you're sitting around the table and you're negotiating the final account, and you and your contractor or your employer, depending on what hat you're wearing, cannot agree on anything. And because you can't agree on anything, you can't really make any progress on agreeing the value of the final account. But if you're the contractor and you think you've got a great case on EOT and loss and expense, but your case on variations is a little bit dodgy, well, what this case says is that's absolutely fine. Pick the best bits, go and adjudicate them, and then when you get back to the negotiating table on your final account, you're in a position to say, well, that's all settled now, so we don't need to argue about that anymore. All we need to talk about are the remaining bits. And so, of course, it's a tactical option that is open to both parties, but I think there is some real potential coming off the back of that decision for parties to think carefully about what in particular they want to adjudicate and how that will fit in to their broader discussions around final accounts. James, could I have the next slide? Thank you. Brilliant. This is another case I'll cover very briefly on multiple disputes. I think James has got another one on multiple disputes, hot topic at the moment. Quadro Services and Cree Concrete, I assume it's pronounced Cree. And what happened here was an adjudication where Quadro had issued 3 invoices. They were totally undisputed, but it was also undisputed that this was in effect 3 different payment cycles. And what the employer said was, well, that's very interesting, but that is obviously 3 disputes, 1 under each invoice. Again, though, court said no. What the court said, come the next slide, James, thank you. What the court said is the fact that it's technically possible to determine whether each individual invoice is due without determining the others doesn't mean these aren't sub-issues in a wider dispute as to whether the claimant is entitled to the sum it claims as due. And I think what you see in both of these decisions is that this really is all a question of framing, right? And provided you are careful when you put your notice in to make it look like whatever issues you're referring are part of a bigger dispute, the court will be quite accommodating. I think that's what these 2 decisions suggest to me, at least. But certainly care does need to be taken. And the court went on to say, well, that if it was otherwise, that would be unsatisfactory because parties would have to commence multiple adjudications. Well, I mean, it might well be unsatisfactory, but nevertheless, to my mind, at least before this decision, claims under 3 separate payment cycles would have looked very much like 3 separate disputes. Can I have the next slide, James? Thank you. Very briefly then, a case about when a warranty is a construction contract. Some of you may be aware of the case of Parkwood Leisure from a few years ago now. This was a case where you had a collateral warranty in which the contractor promised something like, or warranted something like, I promise that I will perform all of the obligations under the building contract. And what the court said was, well, although a collateral warranty doesn't really look like a construction contract, what the contractor has done under that warranty is promised to undertake construction operations. It is a contract for construction operations, and therefore a construction contract under the Act, and therefore subject to adjudication. And over the page, please, James. And a case came up recently here on this topic, Topan Holdings, where the decision went the other way. What the contractor had done, it warranted that it will perform, and it has performed diligently its obligations under the construction contract. That looks like a promise to do construction works, therefore a construction contract. Court says no, because actually what has happened here, what's in the background, is the warranty isn't even executed until 4 years after PC. The only issue outstanding is maybe some liability for latent defects, but at the time they signed this warranty, contractor was not promising to undertake any construction works. Therefore, it's not a construction contract for the purposes of the Act. Those are the cases I was going to talk about, and I'll hand back to James.
Thanks, Dan. Yep, so I've got 3 cases to look at. The first one is disputes arising under multiple contracts being referred to adjudication, and this is Delta Fabrications against Watkin Jones. Brief background, the parties had entered into 2 subcontracts for works at a student accommodation, one for roofing, one for cladding. Later in the project, the parties began administering the payment for both subcontracts together, including one final account. Disputes then arose over the final account, which Delta referred to adjudication. Watkin Jones resisted enforcement on the grounds that the adjudicator lacked jurisdiction because Delta had referred disputes under 2 separate contracts to the adjudicator in the same adjudication. Now, Delta argued that the adjudicator did have jurisdiction on 3 grounds. Firstly, that the parties agreed to vary the contract by their conduct, i.e. by the way they dealt with payment applications, and so there was only one contract. Even if the parties' contract did not amount to a variation, there was only one, so there's only one contract for all purposes. It still had the effect of amalgamating the contracts into one contract for the purposes of the Construction Act. Alternatively, Watkin Jones was stopped from denying that there was a single contract within the meaning of the Construction Act. Taking the first issue, had the parties varied the contract by conduct? No. Following a detailed factual analysis, the court decided that combining payment application was not the same thing as combining 2 contracts. In order to combine 2 contracts, clear evidence would be required, and that was lacking in this case. And also, just on the facts, the parties' conduct before and after the alleged agreement to amalgamate indicated that they had not intended the contracts to be amalgamated. On the second issue, whether the contracts had been amalgamated for the purposes of the Construction Act's adjudication provisions, no. The parties treating the contracts as one purpose of payment was not the same as treating them as for the same purpose of as one for the purpose of adjudication under the Construction Act. The judge also said that she wasn't persuaded that it was possible to have 2 contracts the judge wasn't persuaded that it was possible for 2 contracts which she had already decided had not been amalgamated into one under common law, i.e. the first issue could then fall in within the definition of a construction contract singular under the Construction Act. And the third issue was Watkin Jones has stopped. No, Delta have put forward no evidence to support the three essential requirements for estoppel, i.e. representation, reliance and detriment, and therefore Watkin Jones was not stopped from denying that the contract should be treated as one. On that basis, the adjudicator lacked jurisdiction and the decision was not enforced by the TCC. Next two cases concerned breaches of natural justice and whether or not a decision is severable. Very briefly, Downs Road Development. Downs Road engaged Lex Mabahi under a JCT DB. Strangely, Downs Road had adopted a practice of issuing payment notices that were valued at £1 or 97 pence to gain time to make assessment of the sum it actually believed to be due. It would then issue a further payment notice, say a week and a half later, outside the contractual timescales, sort of showing or indicating the amount that it actually considered to be due. In February 2021, Lex Mabani submitted interim application 34 for 1.8 million. In accordance with their practice, Downs Road issued a payment notice for 97 pence, saying that a further payment notice would be issued in due course. They did issue a further payment notice about a week and a half later, saying that the payment due was 657 grand. Lex Mabani then commenced adjudication. In the adjudication, the adjudicator refused to deal with Downs Road's cross-claim in respect of an alleged defective capping beam, saying that it fell outside of his jurisdiction. He then went on to decide that the true value of interim application 34 was £771,000. Downs Road commenced adjudication proceedings, challenging the enforceability of the decision on the basis that adjudicator failed to address a line of defence that it had asserted. Notwithstanding that, Downs Road suggested or contended, that the decision was still binding as to the true value of interim application 34. The court decided that the adjudicator had breached the rules of natural justice by not considering the capping beam defence, saying that where the adjudication is concerned with a party's entitlement to be paid money, then a defence which would, if successful, remove that entitlement or diminish the sum to be paid will potentially be an issue in the adjudication. The judge then went on to say that the adjudicator adopted an unduly narrow approach. The capping beam claim was being put forward as a matter which the adjudicator said reduced the amount which was due in that payment cycle. Therefore, it is being raised as a defence. If the adjudicator had considered the capping beam claim and concluded that the defence did not operate to reduce the amount due, his decision would have been unimpeachable. However, the court was satisfied that by deliberately deciding not to address this defence, the adjudicator was declining to address a defence which the employer was entitled to put forward and entitled to have considered by the adjudicator. Therefore, the adjudicator had breached the rules of natural justice. As to the other issue on whether the decision on the true value of interim application 34 was still binding, notwithstanding the adjudicator breached the rules of natural justice. It was not still binding. This would turn a single decision with reasoning into a series of separate decisions. And there's the quote there from the judgment. The next issue again deals with breach of natural justice and again whether a decision is severable. This involved CC Construction against Minicoin. The parties' contract was again the D&B. PC had been certified. The CC had issued a final statement. The disputes arose regarding the sum due and in relation to LADs. The dispute was referred to adjudication. Here, the adjudicator decided that the final statement was conclusive and reference to a letter that Minicoin had sent did not prevent that. And also Minicoin had not issued the required payment and pay less notices. The adjudicator also decided that the LAD's claim was not part of the dispute referred and could not be raised as a set-off. Again, the same judge who looked at the Downs Road case found that the adjudicator's failure to consider Minicoin's defence in relation to NADs amounted to a breach of natural justice. However, in this instance, and again, bearing in mind it's the same judge that looked at the Downs Road case, it was decided that the decision could be severed, and therefore it was enforced. And therefore enforce the balance over the amount of Minicoin's NADs claim. And that's it.
Great.
Excellent. Thank you so much, Dan and James. That's been brilliant. I know it was quite a canter through quite a lot of case law, but such a clear and thorough review. I'm sure all of our audience found that very, very useful. Time for probably 2 or 3 questions, I think, if our audience will forgive us. So we've actually had the same question submitted twice, so I'm definitely going to have to run to that question first. Roughly around the same question. It's probably for you, Daniel, I think. In Davenport, the court ducked the question of when the court might restrain a true value adjudication. What sort of considerations do you think the court would take into account? What arguments might be deployed by an employer in that scenario?
I mean, I think that is really an open question at the moment, and you can see why Mr. Justice Stuart Smith didn't want to answer it, right? Because, I mean, there are any number of things that paying parties might try and deploy as to why their true value adjudication shouldn't be restrained. I mean, on the one hand, it might be very narrow. It might be that the only thing they're really interested in looking at is the same sorts of things that they would be looking at if you were trying to get a stay of execution on the smash and grab awards, such as, you know, are they going to go bust? Are they going to disappear with the money? All that sort of thing. Or it could be a much broader inquiry, because I think, you know, if the court is going to injunct a second adjudication, it's effectively a discretionary remedy, or at least a partially discretionary remedy. And I suppose there's a case to be made that the court can look at it much more broadly and perhaps even say, well, what's the real merits here? You know, is it the case where the contractor has got their £1 million smash and grab, but all the evidence points to that being a pretty gross overvaluation? Or is it in fact a bit more balanced than that? And does the contractor look like they're entitled to hold on to all or most of that money? At the moment, it's very difficult to see which way it's going to go, but certainly a fertile area for deploying new arguments. And I expect that we will start to see that in the not too distant future.
Super. Thank you, Dan. And actually, turning back to what you said at the outset, thank you very much for mentioning and addressing smash and grab adjudication, because we would not want to have an adjudication update without one. So thanks again for that. Look, I'm gonna squeeze in one last question. Hope the audience will forgive me again. Open question, general question. Do you think there are more adjudications now than there were 18 months ago? What do you think is likely to happen over the next month or so?
James, do you want to take that, or shall I go?
I think, well, I'm not sure whether there's more adjudications now than before. I think adjudication still offers a very effective form of dispute resolution for parties, certainly in relation to issues of payment. I think we'll continue to see adjudications. I mean, personally, I don't think necessarily there's been more adjudications recently than before. I think they've always kind of stayed the same over the last couple of years.
Yeah, I mean, I think I've seen a pretty steady stream. I think over the last 18 months, probably, while we've all been locked down, I mean, adjudication is almost a perfect lockdown dispute resolution mechanism, right? Because it had always been done remotely, usually just by the exchange of written submissions. You don't ever have to have people in the same place. I think contractors certainly still see the value in adjudication as a speedy mechanism. The law keeps getting better. I think if anyone's interested, that in the last issue of the Adjudication Society newsletter, just giving it a plug there, we had an article from someone in Ireland where they have an adjudication regime which is very new, a statutory regime, and they're just really sort of finding their feet with how that regime works at the moment. But already that is looking quite popular, and I think it will always be popular because it's quick and cheap, and also because it's not final. So you can always take a punt on an adjudication without worrying too much that if you lose, you've lost for all time. So I think, if anything, we will carry on seeing adjudication expand.
Super, thank you. And just generally, James and Daniel, thank you very much for taking your time today. That's been a brilliant overview. The last thing I'd like to do today is give a bit of a plug for our next webinar. Our regular audience will spot quickly that it is not in 2 weeks' time, it's actually in 3 weeks' time, to align with COP26, which begins in the beginning of November. And you will have Jeremy, myself, and possibly another of part 2 of net zero in the construction and energy industry. So hopefully you can join us then in 3 weeks' time, beginning of November. Usual time, 12 o'clock on a Thursday. So I hope you can join us then. But in the meantime, thank you very much to everyone for being here with us today. And we hope to see you again soon. Thank you very much.